This next panel is on innovation and privacy in the era of big data, and even discounting for a lot of the hype, it's pretty clear that the big data already is a catalyst for a lot of innovation across a broad range of activities in both the private and the public sector, and a lot of that was detailed in recent White House reports that came out. But those reports also raised privacy concerns, and those concerns have been echoed at the FTC. Chairwoman Edith Ramirez gave a speech here last year on the question of big data, raising a lot of privacy concerns around the topic of big data. And the FTC has been doing other reports and workshops which also raise that concern. We have a really great panel, I think, to discuss this issue, and I'll go down the list very briefly, and the more detailed bios are in the program. I will also go in alphabetical order, even though I don't think enough people are sitting there. Marjorie Blumenthal is the executive director of the President's Council of Advisors on Science and Technology, and she had major responsibility for the recent very excellent PCAST report on big data and privacy. Tony Hadley is Senior Vice President of Government Affairs and Public Policy at Experian, which is a major data broker and credit reporting agency. I guess we are in alphabetical order. David Lieber is a Senior Privacy Policy Counsel at Google. Maureen Olhausen is a Federal Trade Commissioner. She's been involved in privacy issues for a long time, both as a commissioner and previously in a number of senior staff roles at the FTC. And finally, Max Simkoff is co-founder and CEO of Evolve, which is the leader in big data workforce optimization and was recently ranked as one of the 10 most innovative big data companies. So as I kind of suggested, there's really been no shortage of government attention on both on data privacy generally and more specifically on the topic of big data. In the last year, we had 2 White House reports, the PCAST report and a report by a group chaired by John Podesta. And we also, in this last year, had a report on data brokers come out of the FTC. And these reports followed 2 major reports, again, one from the White House and one from the FTC in 2012. So the question, my first question is, what have we learned from all these reports? Let me start with Marjorie.
Okay. So first, the pair of reports that Tom just mentioned was occasioned on a recognition that big data has a lot to offer. The fundamental concern was, well, what should we be concerned about? So I want to talk mostly about the PCAST report, but let me do a once-over for the areas in which the Podesta report, the White House report, made its recommendations. And there were 6 basic areas. They wanted to advance the Consumer Privacy Bill of Rights idea that had been introduced a couple of years ago, advance the possibility of national data breach legislation, revisit the Electronic Communications Privacy Act, which, in an echo of the last panel, also represents an area where a piece of legislation was based on an older appreciation for technology and what was available. But then it also looked into how one might think about privacy for non-US persons, concerns about whether data that is collected on students can be used only for educational purposes. And then the area that seems to have gotten the most press attention is how to be sure that one can lower the risks of discrimination arising from the uses of big data. The PCAST report was very much complementary, and it focused, obviously, perhaps not so obviously, but obviously on technological concerns. its major message was that if you want to reduce potential harms, then one should focus on how data are used, not simply on what is collected, because for the most part, it's going to be easier, and we'll get into that a little bit later, to address issues of use. It asks that whatever action is taken focus on the goals, on the what of a potential policy, and not on the how, because if one tried to wire in, bake in a particular approach to technology, that's likely to be overtaken by events and new technology. Not surprisingly, PCAST called for more R&D because we have a number of interesting opportunities and possibilities that are not ready for prime time. It called for a larger set of career options for people who have privacy expertise. And then it said that the government should lead by example, that when the government procures and uses technology, it should be sensitive to the privacy issues associated with big data. So this is a large set of concerns, but it's one that allowed for a rich discussion. On the PCAST side, the principal concern is that whatever is done should be technologically feasible. There are a lot of great ideas, there are a lot of aspirations, but we may not be able to act on them. And finally, given limitations of technology, recall the recommendation for R&D, PCAST also said that technology may be necessary, but it won't be sufficient, that it needs to be complemented by appropriate policy.
Maureen, from your vantage point at the FTC and as someone who's been involved in these issues for a while, what do you think we've learned from all these reports, and have we come any closer to some sort of a consensus on policy?
Well, one of the things that we've learned, and I should say I am speaking just for myself, not for my fellow commissioners, is that it's a lot easier to write a report than it is to get legislation passed, right? So, but that doesn't mean that it's not worthwhile to continue to write a report. So our data brokers report that came out in May of this year, I think had some very important points in it. One of the things that I would like to stress, first of all, is that big data, this panel is really about big data. Big data is much, much broader than data brokers. It is not just about using information about consumers. Big data has lots and lots of benefits that can accrue to society that is unrelated to information about individual consumers. So when you think about health research, when you think about transportation, when you think about the things that are being done in agriculture, things like that. So I'd like to make sure we don't assume that the data brokers and big data are the same thing. So the FTC's report on data brokers had some bipartisan legislative recommendations to take action. But one of the things that it really focused on is transparency and accountability. And so we did a 6B study, which is a fairly in-depth study, about the data broker industry to get an idea about what really was happening, what kind of information did they have, how did they share it, what did consumers know about it. And we concluded that the data broker industry really collects a lot of information about nearly every US consumer, and that they share information with each other, and that they combine online and offline data and public sources of data with private data, and they use the data to make inferences about consumer behavior, both online and offline. We found that consumers could get great benefits from this, including things like fraud prevention, better targeted marketing, so that consumers could get better information about the products they wanted, or there could be new products developed. But we also found that there were possible risks that could accrue to consumers, both about improper targeting or improper use of the data, as well as retention of this kind of data. And then we concluded that to the extent consumers have choices about the use of their data by data brokers, such choices are not very transparent to consumers. Consumers didn't really seem to know about them. So we had bipartisan legislative recommendations that focused on giving consumers greater control over the personal information collected about them, and getting the ability to have a little more insight into that. So for marketing products, we suggested that Congress consider creating a centralized portal where data brokers would have to identify themselves and then describe the information that they collect, or have a way for consumers to go from that portal to the data broker site to find out what kind of information they had and if there are opt-out choices and things like that. And then allow some opt-out tools for marketing purposes, and to give consumers a little more insight into how the information is collected, so that if there's some information that's incorrect, the consumer might be able to go and fix that. For risk mitigation products, and that's the kind of product where a company uses information so that if the information about the consumer isn't correct, there's kind of signal of fraud going on there. And that can be very beneficial to consumers as well. And so that's an area where the ability to correct that may not really be the appropriate thing, because it can be the very error in the information is the thing that signals the risk. But we wanted consumers to be able to find out that if they have been denied the ability to engage in a transaction, to find out where that data had come from, because if it was incorrect information, to allow them to fix it. And then for people search products, legislation to allow consumers to access their own information and then to opt out of having it used in that way. So I think the interesting part about the report was how it is sort of, we talk a lot about big data and as if all these things were new, but recently I went back and I did a lot of research on the legislative debate surrounding the enactment of the Fair Credit Reporting Act in 1970, right? So that's more than 40 years ago. And the same kind of concerns, the same kinds of issues were addressed then. It was very interesting to read some of the legislative debate. You would think it happened just last week. So I think that these kinds of issues do come up. I think it's important for us as policymakers to think about them, but to try to get to the right balance, because there are great benefits to consumers from things like credit reporting. There's great benefits to society from that, easier access to credit, a little better information, also getting away from, you just get credit if somebody knows you, right? That was what the credit reporting system was supposed to improve. You didn't have to have a personal relationship with the lender for them to trust you. They could actually have a better source of information, so that we were very aware of the kind of benefits, but also the kinds of harms, and the way the Fair Credit Reporting Act addressed some of this through transparency, through accountability, which I think are important principles to keep in mind moving forward in big data.
Max, you are the person on this panel, the only person on this panel from outside the Beltway, which is a good thing. And you're actually a person who has started and spent your time running a successful big data company. From that vantage point, how do you view the policy debates and discussions in Washington?
So one of the things that we saw from the PCAST report is that there clearly is a lot of concern around discrimination. And I would say that the concern specifically seemed to be around the potential for discrimination, not cited examples of discrimination. And so I'll talk about that a bit and maybe pivot that into how we're seeing big data do good, which was also cited by the report. So when we think about, and maybe I should even set a little bit more context, our company at Evolve has created a predictive analytics software platform that helps large employers make decisions about their global workforce. We have a handful of applications that generally help people make decisions on who to hire, how to manage people, how much to pay them, where to locate them, decisions of that nature. And so the concern for discrimination is great in the field that we operate in. Our customers are clearly very concerned about relying on big data or predictive decisions and the implications it might have for discriminating against people for means of getting employment. So before I talk specifically about how we've addressed that, let me set some more relevant context by saying consider the alternative to using data to make hiring decisions. So recent studies have shown that the average recruiter spends about 6 seconds reviewing a resume. They are generally looking for things like job hopping behavior, education, and work experience. And so the idea that a human being can make data rationalized conclusion about an employment decision off of a 6-second glance at a resume, it stretches the bounds of credibility. And we've now utilized our data to show things like the number of jobs that you've had leading up to your point of application have zero statistical significance on your likelihood of success or tenure within that job. So the idea that job hoppers, people who jump from job to job, are any less likely to stay with a job is inherently false. Similarly, we found things like criminal backgrounds, criminal convictions have zero correlation to somebody's success or tenure in their job. In some cases, people with criminal convictions perform demonstrably better on certain objective productivity metrics. So I guess I just frame all this by saying that the alternative methods we were utilizing before big data analytics, we have now found were vastly more likely to drive discrimination than the methods that our customers are using. So I'll just then finish this by saying we would agree that in the commercial realm, technology providers do have a burden to incorporate the appropriate means into their technology, into their analytics technology, to prevent discrimination. And we do just that. So our software, while it makes a recommendation at the point of hire via a simple green, yellow, red score on an applicant, much like a credit score. So while we provide a hiring recommendation, at this point we're providing probably thousands of these an hour. Some of our companies, customers include companies like AT&T, Kelly Services, Xerox, MetLife, eBay, very large companies. So while we provide this recommendation, our technology has been developed to do so while taking into account the legislation. So we don't have adverse impact on protected classes. It incorporates pass rates for these people. So we feel very much so that technology providers have a burden on themselves to accommodate the legislation and to incorporate the means into their technology to prevent discrimination. And if we do things like that, we think it will become even less of a concern. Discrimination, namely, will become less of a concern in this realm going forward.
So that let's continue with that issue for a bit, because that is the possibility of this theme of discrimination and of big data being kind of a civil rights issue is present in a lot of the recent privacy literature. It was a big theme it was probably the biggest takeaway I think that a lot of people got out of the Podesta report. It is presumably what's driving the fact that the FTC is holding a workshop kind of on this issue very shortly. Why has this become a big issue? Let me start with David and then go to Tony on this. Why has this become a big issue, and what is the evidence?
Yeah. So thanks, Tom. I think it's a big issue because discrimination is a concrete, cognizable harm, and to the extent that big data is being used in ways that create, or enhance the risk of discrimination, it's certainly an area for further inquiry. And I think the big data report talked about the undertaking itself as fundamentally a scoping exercise, and this is certainly another rich area for inquiry. And this is really where the conversation ought to gravitate, I think, in my view, in the sense that we should be thinking about what are the types of harms that we want privacy law to address. And it may be we should be having a broader, more difficult conversation about what those harms are, whether they're tangible or intangible, whether they're concrete or theoretical. And so we saw some of these issues surface in the report that came out of the big data review. And I just think it's something that certainly requires further research, further conversations. I think a lot of what was alluded to in the big data review is theoretical, but that's not to say that there aren't actual harms, there are not actual discrimination that's occurring, not necessarily that it's intentional, but that there may be disparate impact and that we should explore that further.
But also, Tony, could you address the question and also maybe talk about how big data can be helpful to
Sure.
lower income people or other of the groups that.
Happy to. I appreciated the fact that the big data report and some of the data broker reports focused on discrimination. because it was a good reminder to industry of all types that we as a country have established firm law in the area of lending and employment and education and access to health that is supposed to be fair and non-discriminatory. And so to refocus those who share and use and analyze data, whether in a data broker or in a big data context, on those fundamental rights that people have are important. And of course, one of the conclusions of the reports, the many reports that have been done on data over the last 2 years, is that there are potential harms, but no evidence of real harms, because the real harms are covered already by sectoral law, whether it's in credit reporting or fair lending or fair housing or equal opportunity, equal employment opportunity, or education or health laws. But yes, to the extent that information and big data could potentially be used and in a way that leads to discrimination, people ought to be mindful that there are laws that they have to deal with. And big data does not obviate a industry or a company from being mindful of the laws that exist with respect to fairness. Now, one of the things that the reports focused on too was this notion of inclusion or exclusion. And I think it's important to understand that big data actually is going to have the opportunity to be inclusive rather than exclusive. And here's a couple ways that we're using big data as an inclusionary way and rather than an exclusionary way. I'm going to talk about financial inclusion. That is to say that 55 million Americans do not have a credit score, or such a thin file that they cannot be scored and get access to mainstream financial products and services. Who are they? They're emerging consumers, people out of college, immigrants, some elderly people, some just very poor people who have never entered the credit system. But how do we find ways of including them so that they can get access to mainstream financial offerings and can move away from predatory lenders or payday lenders that continually trap them in high-priced short-term loans? One of the ways we've been able to help solve this problem in part is through big data and big data analytics. Just earlier this year, for example, we released version 2 of VantageScore, which, using big data analytics and attempting to try to move away from categories that have historically been used to grade a person's creditworthiness and into other areas that are proxies for creditworthiness, can score 30 million more consumers than VantageScore version 1. So that's big data analytics at work with big data sets in order to find out how we can move into financial inclusion rather than financial exclusion. The other thing that we're doing, and this points again to the issue that more data, not less data, is what's going to be necessary for financial inclusion, is we're identifying proxies for creditworthiness that individuals undertake on a routine basis, but aren't traditional credit activities. We call it alternative credit data that operate and can be scored exactly like credit behavior, such as the rent you pay, the telecom payments you make, the utility payments you make. And so getting access to this type of data, combining it with other large data sets, creating proxies for good payment history, can create financial identities where none exist, can create credit scores where none exist, and can thicken thin credit scores that can't be scored. And so I think there's real opportunity in using big data analytics for financial inclusion, trying to get at some, we'll probably never get at all, of this 50 million segment of our population, that's 1/6 of consumers in the United States, that don't have access to mainstream credit.
Yeah. Marjorie, you wanted to add something?
Yes, I think that there, as a technical proposition, both Max and Tony described how some of the new techniques can be used to promote inclusion, and that where the concern is arising is where people are concerned about what Max described as uses of correlation and Tony's description of uses of proxies. There are people that we talk to in the process of our studies who use the same techniques to say, well, these might also be exclusionary. So part of what you're hearing is the technologies themselves can go either way. And I think, as Tony in particular has said, as well as Maureen, you need the legal framework to make sure that the use of the data, which is what PCAST emphasized looking at, is consistent with the legal framework and promotes the more positive outcomes.
But none of these reports actually, I mean, Tony mentioned this, but none of these reports actually had actual evidence of big data being used in a discriminatory fashion. It was all the possibility.
Right. I think in the Podesta report, there was a description of one particular municipal application where a potential for an exclusionary impact was seen early enough for there to be an adjustment in how it was used.
Right.
One of the things that's important to understand is that in these areas of fairness that we've established through law, I'll use fair lending as an example, there's an incredibly robust financial regulatory apparatus that force lenders into fairness. And they don't end with the FCRA, and that is what kind of third-party data are you using to make an eligibility decision. They go to an observance over a period of time of disparate effect on populations. And so the regulatory apparatus that exists there is that every lender, by virtue of their regulatory threshold, whoever it is, whether it's the CFPB or the OCC or the FDIC or the NCUA, is forced to show their regulator how the models they use that lead to lending, the data they use that lead to marketing offers, the data they use in eligibility determinations, how that model governance program works to ensure that the end result is not disparate activity. So we have that same notion in equal employment opportunity. I think what we're attempting to try to do here with these big data reports and these data broker reports is attempt to try to discern whether or not we should assemble these large-scale and robust fairness structures and regulatory structures over commercial data sets that don't lead to substantive decisions, but rather whether somebody gets a marketing offer or not. And I think therein lies the disagreement about how we go forward. Should marketing data be regulated like credit, like employment, like lending data? And I think the clear indication that we're getting from Congress is no. There might be this many members of Congress who want to go in that direction. So we're not going to see law passed in this area, but that doesn't mean that we shouldn't be mindful of best practices that should be met as businesses, especially those that concern existing law. Now, there's this notion that data in general isn't regulated, that for some reason there's a dearth of regulation around data in the United States. But let me tell you this. My compliance department tells me that for the data assets that Experian has, which may or may not be sizable or proportional to any of the data assets that your companies have, we comply with 300 state and federal laws. 300 state and federal laws over the data we maintain and use. Every data element that Experian has a use according to a law. And where law doesn't exist, in self-regulation, standards that have been established by our trade groups. So the idea that there's a lack of data regulation and that one more law, the 301st law, will bring sense to consumers who truly are concerned about transparency of data, they don't know how it's collected and used, is something that I think is questionable.
Let me move to another, since you're talking about regulation. I think an important issue to come out of the recent reports, and an important issue that's been discussed in the context of big data. I mean, for the last several decades, the whole privacy policy discussion has kind of revolved around the fair information practice principles and a bunch of other things that basically go into the Consumer Privacy Bill of Rights, which is kind of the basis for what the administration would like to propose in terms of legislation, the OECD principles, and all of these things in one way or another focus on limiting the collection of information, the use of information, the retention of information. Both of the White House reports, as well as others, have discussed the implications of big data for that approach, and kind of raise questions about whether big data is consistent with whether the way big data are used is really consistent with those approaches. And Maureen, you have said explicitly in comments that you recently wrote that there is a tension between FIPS and the way big data are used. You want to expand on that and maybe talk about whether you think that tension can be resolved?
Yeah, I'm happy to talk about that, and I also think it's something that the PCAST report identified very, very clearly as well, and raised some similar concerns, which is the idea. So we've got notice and choice, right, as the primary model, notice, choice, access, and security being the FIPS principles. But when you move to a world of ubiquitous collection of data, and with big data, I think one of the insights of big data is taking data sets that previously were separate, that were collected under different circumstances, and then you combine them to create new insights that you didn't even know could emerge. That the notice function becomes particularly difficult, right? Because at the time you're collecting the data, you may not be able to get consent for an unanticipated use of that data. So my view has been that we should think seriously about a harms-based focus. The idea that will this data be used in a way that will harm consumers, and that's what we really should be concerned about, rather than saying, well, was the privacy notice clear enough? Now, but to put that into perspective, I still think that the FIPS-based approach has some real utility. When a company is there saying, I'm going to collect your data and here's the only way I'm going to use it, they should be held to that promise. That might be a way in which they're competing among their competitors in the marketplace, and that's something we've seen emerging as companies are competing more based on their privacy offerings. So I think privacy policies can play a useful role. I know consumers don't necessarily read them a lot, but I think there's a lot of consumer watchdogs that will monitor those and surface things. Roger Null was talking a lot about the power of the internet. The internet has been a really fantastic tool for surfacing some privacy concerning practices or some privacy violations and getting that out very widespread without an individual consumer necessarily having to go through all of that. But I do think when you're looking at the possible benefits of big data, having a harms-based approach. Now, I do think that for certain types of information that consumers have traditionally seen as very sensitive, and we've got already sector-specific regulation in certain areas around health information, around financial information, that consumers would see it likely as a harm if I gave my information to my drugstore to get a prescription filled, and then that was shared, and then later on it was identified with my name, and it was used in some other way that was personally identifiable. I could see that falling under a harms-based approach pretty clearly. So I do think that there are some tensions that need to be resolved, because of the long-term benefits of big data. I also think the PCAST report did a good job of talking about what are some of the ways we can manage these risks and minimize these risks, because I do think there are risks, there are possible harms, but we need to manage them.
Right. Max, as a user of big data, what impact do you think a FIPS-based approach would have on your ability to use data?
So, for us in particular, it probably won't have much of an impact. We have defined our own big data code of ethics that we have voluntarily, shared with the market, and it says it's very much aligned with some of the tenets of the Consumer Privacy Bill of Rights. So, the first tenet of ours is be transparent, right? Tell people exactly what you're going to do with their data. We will collect previous employment information, biodata. We will gather explicit characteristics about your behaviors, aptitudes, skills. We will use them to make predictions about whether or not you will be a good fit for this position. If you are uncomfortable with that, you should close your internet browser, right? We don't do shadow data capture. So a lot of the things, a lot of these other companies are combining data sets to come up with new insights, and they do so by buying data from third parties, by scraping data from websites. Many of you would be shocked to learn about how some other companies in our commercial marketplace are, quite frankly, in a very shady way, scraping publicly available information from people's LinkedIn profiles or social media. We don't do that, right? We only take the data that you've explicitly consented to give us to run correlations against it. So by and large, we're again, I think, and I want to be careful to say that we're in a unique realm. In the realm of using technology to make predictions about employment potential, we think that there's a very manageable way to operate within the letter of the law right now, and to correspond with a lot of the direction of regulation. We don't necessarily have an issue with having to comply with some of these things.
Marjorie? Yeah.
So just to follow up on both Maureen and Max, and to recognize that a few of us in the room just spent a few days at the Aspen Institute with some overlapping discussion and some clear champions for FIPS. So I would say that one can look at them as a kind of aspiration, but it's important to understand where fulfilling that aspiration breaks down. And in particular, one can look to the idea of transparency, as Max has said, as I know Google has talked about in other contexts and so on. And just to go through the thought experiment of how is it possible, where does it work, where doesn't it work? I think one way of thinking about what came out in the PCAST report is that there is a change in the balance of power, not that we use that expression, so that the individual doesn't particularly have a nexus with the connector. That's particularly true when you think about a lot of sensors in the environment. And again, here is where you can speculate as to where transparency might actually work. The point that Max made about data integration is one that shows how well that nexus with the individual is just disappearing if it exists at all. And that then puts the onus on the user of the data and the analytics to do the right thing. So thinking about the FIPS, it's hard for anybody to argue that security is of enduring importance, although as PCAST pointed out, security is not identical to privacy. And I suspect that the FIPS pointers to auditability and accountability will become more important. We may not be able to do all of the ex ante things that the FIPS call for, but we may be able to monitor and enforce ex post, which is where those come in. Finally, Max had mentioned having a code of ethics. And I would note that in June, a number of people from higher education contexts who were worried about whether there would be regulation of the use of data from some of the online education platforms, chilling what that research opportunity might be, which would benefit learners, they came together at Asilomar and developed an ethical framework for the use of data from online platforms, and you can find that on the web. But I'm guessing there will be a number of instances where in specific sectors or industries, as well as specific firms, you will find at least some articulation of ethical principles. The question, I think, for Maureen and for other people is what does government do to build on the voluntary codes of ethics, recognizing Tony's concerns that maybe sometimes voluntarism has its place.
David?
Yeah, so I mean, I wanted to underscore something that Commissioner Olhausen alluded to before, which is, the big data review, placed significant emphasis on a responsible use framework, but that doesn't necessarily suggest that traditional FIP should be abandoned, displaced, or supplanted. There are going to be many instances in which notice, choice, and consent should persist, and for accountability reasons, you will want to have a privacy policy that's actionable and enforceable. And the privacy policies these days serve more of a transparency function than they do in terms of a notice function. We've all heard complaints about privacy policies, that they're not readable, that they're legalese, that they're essentially defensive mechanisms for companies. I think that's why you've seen companies, and Google in particular, experiment with the way that we deliver notice. We've done so through privacy videos, contextual notices, butter bars, just-in-time notices, all sorts of things so that when important privacy interests are at stake, that users are informed at a time where they can actually exercise choice about whether they want data to be collected or used in particular ways. I would also say, too, that there's been some criticism that the responsible use framework really places too much faith in how companies would exercise discretion in terms of drawing the line between appropriate and inappropriate uses. And I would just submit that it actually is an important accountability mechanism. If you do believe that notice, choice, and consent has outlived its usefulness in the sense that simply reading a privacy policy and continuing to use a service or website suggests consent, and that doesn't work in terms of accountability. If you have a responsible use framework, it puts the onus on the company to make sure that the uses are appropriate and that there aren't risks of harm or harms themselves that are caused by those uses.
Well, why don't we open it up to the audience, because we don't have that much time left, and see if there are any questions. No questions? Yeah. Why don't you wait for the microphone and identify yourself? Right there.
Thanks. I just want to thanks the panel. I thought it was a fascinating.
Could you identify yourself?
Yeah, sorry, Joshua Meltzer from the Brookings Institution. I thought it was a fascinating discussion, so thank you very much for that. I just want to pick up on the discussion around the value going forward of consent and notice in the type of data world that we're talking about, and particularly I think Maureen's observations about whether we move to a more harms-based approach. And just ask for the panel's opinion on what tensions this might create, or how we marry this with the European approach to data privacy, which is deeply embedded, I think, in a consent-based view of data and privacy. We see this reflected in the Safe Harbour framework, and certainly, the Europeans are in the process of updating their laws in this space. And so, if you envisage a more optimal approach being something which incorporates a more harms-based approach, is there space for the Europeans to go down that path, or is this going to be an increasing place for disagreement and conflict over this issue?
Yeah, that's a good question. Who wants to tackle that?
Sure, I'll jump in to begin with. So, obviously we have the safe harbor, right, for sharing data between the U.S. and the EU, and it's been under some pressure recently given the Snowden revelations. But one of the things that I think is important to focus on is not that we're ever going to be the same, that we should expect the US and Europe to be the same. What we need to focus on is being interoperable, so that we have a system that they can understand, that they can live with, so that some of the things that we do in the US about, companies have to adhere to their privacy policies. They have to meet the adequacy principles of the EU Safe Harbor. The FTC has actually brought a number of enforcement actions against companies that have let their adequacy certifications lapse, but still claim that they were adequate. So I think that there's a way for it to be interoperable between the two regimes. Another interesting thing that's happening in Europe, though, is they're actually doing a big data review. And they're looking at some of these issues. I think it's happening under the info. I think it's called InfoSec. It's not their traditional privacy area. It's more of their business-oriented regime, that they're looking at this issue, because I think they are also starting to think about some of the real benefits of it. I was recently on a panel with some folks from Europe who are going to be undertaking this review, and they were asking these same kinds of questions. What are the benefits of big data? How do we make sure that society gets those benefits while managing the risks to consumers? So I think, I hope it's not something that will drive us further apart from the Europeans. I hope it's something that we can continue to focus on. How do we make our two systems interoperable?
David and then Marjorie. Yeah.
Yeah, I mean, I would, say that one of the biggest challenges that we do face with big data is government surveillance. The current sort of review of the EU Safe Harbor framework was sort of precipitated by the Snowden revelations. Tom, you asked before whether there's any consensus on policy. If you look at the specific policy recommendations that emerge from the big data review, there is consensus on at least one of them, and that's updating the Electronic Communications Privacy Act here in the United States to require or create a bright line warrant for content standard. And there are 263 co-sponsors of that bill in the House, and I don't know whether there are half that many co-sponsors on other pending legislation, but there are ways to move the ball forward on this, particularly on surveillance. And so we can make progress in the short term on some of the issues that have been raised here. There is consensus to do that. It's just a question of how we push that ball along. And I think those successes that we potentially can have here in the US can reverberate abroad to show other countries that we're serious about privacy reform.
Marjorie.
So PCAST was very critical of notice and consent as not being meaningful or practical. But they also offered a suggestion that perhaps for this conversation could be interpreted as a way of thinking about implicit consent. So I'll summarize that very briefly, not particularly to advocate for it, but just to say that there may be different ways of organizing what we do than the ones we have today, that again could be in the spirit of FIPS or any other particular framework. And in this case, they suggested that there might be a new kind of intermediary that would vet the way different kinds of apps or businesses do what they do, and basically offer consumers a choice of bundled alternatives, so that this intermediary helps to make something like notice and consent a little bit more meaningful in this new technologically shaped world.
This would be a private sector intermediary?
Yes.
Yeah.
Yes.
Well, Baron.
Thanks. Baron Soka, Tech Freedom. I'll direct this to the Commissioner in the first instance, but I'm curious to hear what everyone else thinks as well. So I very much appreciate the conversation that you all have been having about focusing on real harms and talking about the laws that already exist. Many of us were left scratching our heads reading the data broker report when the Commission leads with the example in the report and in its press release of talking about motorcyclists who might get ads about motorcycling, that being good, but then it being a problem that they might be discriminated against in their insurance eligibility or pricing because they engage in a high-risk activity. The Commission doesn't mention that that's already covered by FCRA, that the Commission already has interpreted that to apply to hazardous sports. So I'm just wondering, what's going on in terms of the thinking about how to deal with things that might already be covered by new laws, or what lessons we should draw from the experience of them, or where the shortcomings are? What's the problem that we're trying to solve? Is it, as Tony's saying, that those laws don't cover the offering practice in marketing, or is it that there's a shortcoming in eligibility and pricing in insurance laws and lending laws and employment?
So we're obviously very aware of what the Fair Credit Reporting Act covers at the FTC, and I think that was discussed in the report. But I do think that there is this question in consumers' minds about what information, so it's data brokers are not consumer-facing organizations, right? So maybe I've shared that information with my Harley-Davidson dealer, but I didn't know that that was being sold on to a data broker who's combined it with other information, and it's being used for other purposes. And certainly, if it is being used for a purpose that violates the Fair Credit Reporting Act, the law already covers that. But the idea was to give consumers, the recommendation was to give consumers a little more insight into what happens to their information beyond when they've surrendered it to the party that they're doing business with. And are there other uses of it that make consumers be concerned that it's being used in a way that will disadvantage them. Now, certainly, we have brought a couple cases against companies that have used social media and other data in ways that violate the Fair Credit Reporting Act, and we've brought enforcement actions against them directly. So there are possibilities that can happen. I think the only thing we really identified that may not be covered by the Fair Credit Reporting Act is for a risk mitigation product where information is being used to deny the consumer the ability to engage in a transaction. And the consumer doesn't get an adverse action notice. They don't get insight into why was I denied the ability to engage in that transaction. But personally, I didn't see it as saying, oh, well then, therefore it means that, marketing data, using data for marketing is a bad thing or shouldn't be permitted. Certainly, the Fair Credit Reporting Act doesn't allow credit information to be used for marketing. So I don't see it as going in that direction, but just giving more insight into consumers about how this data is being shared and used.
Actually, I want to have time for one last question. That the gentleman there had his hand up.
Hi, this is Rahul Tilang from Carnegie Mellon. So sometimes the school of thought is that it's the political uncertainty and the policy uncertainty which hurts both the firms who are trying to innovate and the consumers who are trying to engage. Even a stringent regulation might be just fine if we all agree on it, everybody kind of adjusts to that new equilibrium, or vice versa. So I'm just curious whether there is going to be a broad agreement about the big data and the data use, at least in the policy circles, that we are going to have, or we are just going to have this uncertainty about what our next step should be or should not be. So I'm just curious, both from a private firm's point of view, how they look at, where the future is, as well as from the policymaker's point of view.
We should have a brief answer, and then we need to move on to the next panel. But
Well, to me, the issues of uncertainty about the use of big data are nil. There are no uncertainties. There are 300 laws that have to be followed when you're using big data. The notion that you can take all kinds of data and just combine it and mesh it together and make a decision out of it is a fallacy. You cannot combine certain types of data with other types of data unless permitted by law. And so I'm hoping that as we continue this discussion, and I applaud the FTC for doing it in the next big data report, we continue to look at what real gaps exist in law, identify those gaps in the 300 laws, and fill those gaps if appropriate. But I don't think we can get to moderating the uncertainty until we've done that, until everyone understands that there really is no uncertainty about how you can use big data. It's all prescribed by law right now, unless you can identify one that isn't. And nobody's been able to do that yet.
so I'd like to thank the panel for a really great discussion. And